Committee Room questions as we go over to BBC Parliament here on BBC Two.
Order. Welcome to this afternoon session of the Foreign Affairs Committee of the House of Commons on our ongoing inquiry into the Brexit process. Secretary of State, you're very welcome. I note that this is your second gig in 2 days, and that you told the House of Lords, the European Union Scrutiny Committee yesterday, that appearing in front of them was a particular pleasure.
Which I hope to repeat today.
Well, is that the reason you chose to schedule a meeting at that end of the building first?
I didn't even do the scheduling, Mr. Chairman. It's between your clerks and my office. So,
well, I don't imagine the scheduling with the House of Lords Committee was with our clerks. Presumably you made
your
some.
scheduling was with your clerks,
made some kind
their
of decision.
scheduling was theirs.
You made some kind of decision to go there first, and that's the gentle hook I want to take into my next question, which is to examine your assessment of the legal and parliamentary implications of the Brexit process. Can you confirm that there is going to have to be an act or acts of Parliament in order to leave the European Union?
Oh, there had to be some legislation, there's no doubt about that. I mean, there are various stages. Firstly, there'll have to be some legislation to deal with the European Communities Act 1972 and all the consequential legislation that follows on from that. There may well have to be at least parliamentary ratification under the relevant 2010 legislation, the so-called CRAG legislation, and well, that's the absolute sort of minimum I can see.
So that we can't leave the European Union if that legislation is not in place, crudely?
Well, we can leave, but what the legislation does is put in place directives. What the current legislation does is put in place directives and various other pieces of law, which would still have effect if we didn't eradicate it.
But the question.
So whilst we'd have taken a treaty change to remove ourselves, we would, in that circumstance, still be reporting back to the European Court in some respects, I think.
But what I'm seeking to establish is that there are acts of Parliament either to be put in place or to be repealed as part of the exit process.
Yes.
We cannot leave.
That's correct.
So therefore, in handling this goes to the reason perhaps you were down the other end of the building rather than starting here, is that my assessment is that there is a majority in the House of Commons to support the Prime Minister in Brexit means Brexit, and despite the fact that a number of Conservatives were campaigned to remain in the European Union, they've accepted the decision of the electorate and will now support the government in the process of leaving. However, it's my assessment that you could not be as confident that that's the position down the other end of the building in the House of Lords. Would you agree with that?
Well, first thing is you're wrong about the calculation, and there was no calculation in terms of who we saw first. Secondly, I haven't actually made an assessment of what the balance of power or the balance of interest or the balance of voting would be in each house. It's a little early to do that. For a start, any legislative change would, I would think, be based, at least in part, on where the negotiation had got to by then, and whether or not various individual members of each house approved of what we'd done. So I don't know where we'll be. My hope and intention is that we'll have a majority in both houses.
Well, can I gently suggest to you that the government could be reasonably confident of a majority at this end of the building in order to carry out the decision of the British people in the referendum?
Yeah.
But that is a rather more open question about the attitude of the House of Lords, where the government is in a significant minority in the House of Lords, and there are a number of Conservatives, Lady Wheatcroft amongst them, who appear to be very determined to try and obstruct the country's route to Brexit. Now, if you were in that place, then obstructing the acts of Parliament that are required to enable Brexit is something that's going to have to be overcome by the House of Commons using the Parliament Act. And so what I'm suggesting to you, that whether you would agree, it was actually quite a sensible idea for the legislative process to be commenced in sufficient time for it to be on the statute book, having overcome opposition in the House of Lords by the use of the Parliament Act, so that we can leave the European Union in the early part of 2019.
Well, again, I'll challenge the basis upon which you make your argument. The simple truth here is that what the government is doing is carrying out the biggest mandate that's ever been given to a government by the British people. The largest number of people, nearly 17.5 million people, the majority of over 1.25 million, I think. Had it been a general election between two parties called Leave and Remain, the majority for Leave would be bigger than the majority Mr. Blair had in 1997. So it's a very, very, very clear mandate. And I think the House of Lords would be quite unwise not to take that mandate seriously. They've got a perfectly reasonable position in challenging some of the elements of whatever negotiation turns out at the end of this. But I would be very surprised if they were unwise enough to go down the route of just blocking it full stop.
Well, it's already been the view of this committee that the government was guilty of gross negligence in not preparing for the possibility that the country might actually vote for Brexit. It might also be imputed to be the view of this committee that it might amount to gross negligence if you proceeded on the assumption that all was going to be hunky-dory down the other end of the building and you were going to get your legislation in good order because the House of Lords were minded to obey the instruction of the British people and were going to behave in your judgment wisely. Wouldn't it be rather more prudent to make sure your legislation was in place in sufficient time to actually allow us to leave the European Union?
Oh, that would certainly be true.
On a date of the government's choosing, or indeed at the conclusion of the negotiations 2 years after we give notice under Article 50.
If I may say so, Mr. Chairman, you're jumping to the conclusion of a committee report about a decision I have yet to take. So that's not just getting me ahead of myself. I suspect it's getting the committee ahead of itself. Look, I am clearly intending to get us to the position of leaving the Union within the normal Article 50 timetable, and I will make the legislative arrangements that are necessary to get there. That is the simple case of the matter. I will not, I'm afraid, hypothesise with this committee or any other about the way either house will vote. That's for the whips to do, that's for the usual channels to do, and I, of course, will make decisions based upon their advice. But I certainly won't be airing such decisions in public any more than I'll air some of our negotiating decisions in public in such a way as to jeopardise them. Same problem, and I'll behave in the same way.
Well, turning to that matter, I'm grateful for your reply this morning to my letter to the Attorney General on legal issues regarding the United Kingdom's exit from the EU. I wrote to Jeremy Wright on the 29th of June 2016. I invited him to reply by Wednesday the 13th of July. I'm delighted that we finally got a reply on the 13th of September.
Albeit from me.
Albeit from you, which I'm still, you are speaking on behalf of the government, so I'm very grateful.
Yeah.
What I'm slightly less satisfied by is the terms of your answers, and would want to explore why you're unable to give answers to some rather basic questions. The first question I put to the attorney was, can all of the directly applicable regulations that currently apply to the UK be transposed into UK law in a single act of Parliament, should Parliament wish to retain them? Now, that struck me as a rather straightforward question. And your reply said, you will appreciate that the questions raised in your letter touch on issues which are currently the subject of legal proceedings to which the government is party. There are areas raised by them which it would therefore not be appropriate for me to comment on. Do please explain how a simple technical question about whether or not it's possible to use a single act of Parliament impinges on an action being taken against the government about the operation of Article 50.
About Article 50, exactly. I mean, I can talk to you about the issues relating to the Act of Parliament. Let me do that here and now. There are a number of ways you could put into effect such an Act of Parliament. One of them is to have a portmanteau act. puts everything in place at once. It would be huge, and to come back to your position earlier about timing on this, it would have to wait until very late on in the process, because we'd need to know what we were doing with each component of the exit from the Union. And even were it a really simple exit with almost no amendments to it, and were we setting out in order to do all the changes later on, it would still be very complicated, because let me pick a trivial example. When local government does purchasing decisions, under European law, they have to put the bid into the European Journal. Now, clearly, that would be simple. So it had to deal with all those tiny things, either directly or with on spectacular Henry VIII clauses in lots and lots of SIs. So that's one aspect of it. The other way to do it is very simply, but then it still leaves you exposed to all those problems, and then you could do it rather more early, and then have a whole series of successive bits of legislation. So there's a problem. You see the problem. A simple one.
I'm not entirely sure that I do. First of all, my question was how does the question you opposed in my letter to the attorney impinge the excuse you gave for not, or the reason you gave for not answering the question? Was that it impinged on the legal action?
From memory,
I don't understand
from memory,
that
Chairman,
connection.
From memory, Chairman, I don't have the letter in front of me, but from memory there was a reference to Article 50 in it, wasn't there?
No, there's no reference to Article 50. The question posed was, can all of the directly applicable regulations that currently apply to the UK be transposed into the UK law in a single Act of Parliament, should Parliament wish to retain them? Your answer is this is currently the subject of legal proceedings. And therefore you...
In that case, that was an error, because I thought it was a reference to Article 50 in it too.
No, there's no reference to Article 50 at all. I wonder if you could have another go at a letter to the committee answering that question.
We can, of course, but we can also deal with the issue, the substantive issue right here, which is the nature of the legislation that you are likely to carry through. You can either have very simple legislation, which meets your requirement of going early, which you raised earlier, with the sorts of logic.
Well, what's the simplest? Is there? I mean, I suppose the position I'm putting is that my assumption, as being I want to test, is that you've got all this directly applicable regulations which have not been put through by SIs and anything else, so not in British law at the minute. We're going to leave the European Union. Do we try and make a judgment about whether these 6,987 regulations that directly apply, that we go through them one by one and decide which we're going to keep and which we're going to leave when we leave, or are we going to put all of them into our law and then take our time to go through and decide which ones we don't want?
That's right. And the decision one has to take is whether one has a simple piece of legislation with a cascading set of SIs following on from it, which and you raised the issue of the House of Lords. The House of Lords famously doesn't like Henry VIII clauses. It does not like things that create lots of statutory rights for ministers rather than go through primary legislation. Or you could do it with a small piece of upfront legislation and then a mixture of primary and secondary, or you can do a huge portmanteau which would have to be late, because you would need to know what the changes were before you started the legislation.
Right.
Take my point. It's quite important.
Yes, no, I think
clear.
I think what you've said in answer to question one is yes, which is obviously for which I'm grateful for an answer. And there are options. There are options beyond that.
Let us be clear, Chairman. I don't want you to take a misguidance from me. My answer to question one was yes. What was question one in this context?
Question one was, can all of the directly applicable regulations that apply currently in the UK be transposed into UK law in a single Act of Parliament?
Yes, they can.
Well, I'm grateful for that clarity. Perhaps we can have a bit of a go on the second question I was posed in the letter to you, and I wonder whether we might be possible for to put a copy of the exchange in front of the Secretary of State to ease it. But let me, for the benefit of the record, the second question I then asked you: on what terms will the UK and the EU trade at the end of the 2-year negotiating period mandated by Article 50 of the Lisbon Treaty, if no deal has been agreed between the UK and the EU on the terms of the UK's exit from the EU and or no deal has been agreed on the terms of the future relationship between the UK and the EU. So what that posits is the rather obvious possibility that there is either a blocking minority amongst the 27 who decline to come to an agreement, or the European Parliament has a majority against whatever is negotiated between you and the 27. Now that strikes me that's a rather obvious possibility, and the answer you gave to me in the committee was, turning to trade, we are about to begin these negotiations, and it would be wrong to set out further unilateral positions in advance. As the Prime Minister has said, the UK will strike a bespoke agreement that gets the best deal for people at home and the right deal for Britain abroad. Well, that is not in the gift of the Prime Minister, is it? It is going to have to be an agreement between us and our 27 partners, endorsed by a majority of the European Parliament. So the Prime Minister can't make that statement.
No, that's the Prime Minister's aims.
That's her aims, yes. But that's her aims, but the fact is she can't guarantee it,
No.
as neither can you.
No, nobody can guarantee the outcome of the negotiation before.
So therefore it is
That's one possible outcome.
that is a possible outcome.
Yeah, I wouldn't,
And
I wouldn't use the phrase bottom line.
But all I've done is ask you, or I asked the Attorney General, and you were kind enough to send me a letter which
Yes.
hasn't
Perhaps I'm wise enough, Chair, I might have the right answer.
hasn't, in my judgment, entirely addressed the question, shall I say? But I think it's just a rather simple, straightforward question and I think there's a very important reason you should answer it as soon as you're in a position to do so, it's a kind of technical question. What happens if there is no agreement? Because that then addresses a vast amount of the uncertainty that is out there. For example, in the memorandum from the Japanese, for example, that's people looking for certainty as to what happens. If it's clear, if there is no agreement in the negotiations, what the position is, then you address a vast amount of the uncertainty that's out there in individual companies and the rest, and they can then watch the negotiations and make their commercial judgments according to how they perceive them as going, given whatever guidance you're going to be able to give. But then they will at least know how bad it can get from their position, or how good it can get if there's no deal. It might be an opportunity for them if there was no deal. But just simply explaining what the technical position is going to be in our terms of trade into the single market in those circumstances strikes me as A, answerable, and indeed necessary to answer.
Well, it depends what you're after. I mean, if you're after a factual statement of what the outcome could be, it's, I guess, what is normally known in the world at large as World Trade Organization rules. That's what I guess the conclusion is we're outside the union with no deal. But I would not want anybody to think that was, in my view, a likely outcome.
No, I'm not asking whether it's a likely outcome.
Yeah.
I'm not inviting you to put a probability on it. I'm inviting us to get to an agreed understanding that it is World Trade Organization rules on most favoured nation status that will govern the sales of UK services and UK goods into the single market, and indeed the reverse.
That is a matter of commonly held fact, I think.
Well, that's all I was seeking to get the confirmation of, because there have been people who've been suggested that there are complications with the World Trade Organization rules and position. And if you're telling this committee that's a matter of commonly held fact, and it is a fact, then that gives everybody a bottom line from which to work. All the interested parties, which obviously, as you know, are a very large number, can then begin to go.
Well,
this is
except, and this is one of the problems here, because we're dealing with a negotiation, which, as I said yesterday, is extremely complicated, and the World Trade Organization rules essentially apply just to tariffs, not to the non-tariff barriers that are one of the primary issues. So it's a simple answer to you, but it doesn't encompass everything.
No, I understand. Of course, there's then a complexity about how the non-tariff barriers are operated and the rest. But I think there is a very great need for as much clarification of what can be reasonably clarified, and it's kind of the obvious bounds of which a negotiation could take place. And obviously, one of the bounds is no agreement. For that to be for that to be clearly established and put out there. You've gone a very great deal further in answers to me than the letter you probably signed off in some haste this morning when you realised it was outstanding.
Well, it wasn't really outstanding for me. Is that something?
No, I realised someone probably turned up and said the Attorney
worthwhile.
General hasn't done this. Do you mind? I appreciate that, and I'm grateful
no
for the.
No good deed ever goes unpunished.
I'm very grateful for the detail you've now. You've now given. Just one further question for me before moving on to Mr. Gates. Who are you going to be, to Mr. Howie, who are you going to be negotiating with?
Well, it will vary, I think, by state. I mean, to give you an example, well, first off, the Commission has appointed Mr. Garnier. Mr. Barnier, sorry, not Mr. Garnier. That would be lucky. Mr. Barnier, Michel Barnier. The council has appointed Didier Dessous. The Parliament has appointed Mr. Verhofstadt. They're not quite sure what their locus in this is. And of course, on a national level, we're talking to a whole series of people. So, for example, last week I went to Dublin. And I spoke to Mr. Flanagan, the Foreign Secretary. I spoke to the Justice Secretary because they have. No,
I understand. Informal discussions. Obviously, we'll go around this. My question is, in a sense, who are you formally negotiating with?
Well, the formal negotiations with the Council. That's what the Article 50 says. Or there'll be and via the Commission, but the decision will be by the Council.
There appears to be some dispute between the Commission and the Council
well, that's
about
between
how this
them,
will be.
and it's not for me to resolve. If you forgive me.
We may come back to the involvement of the European Parliament later in questions when I turn to Mr. Zahawi.
Thank you, Chairman. Secretary of State, I just want a little bit more clarity on question 1 in the letter when you say it is possible to have a small piece of legislation where we adopt all the 6,800 EU legislation, but I thought you then went on to say that that would be problematic and gave the example of the local authority having to publish all their tenders in the European Journal, so therefore it wouldn't be workable, i.e. the yes and no.
You'd have to deal with that by a series of follow-on legislation, mostly SIs, I guess. Right. Something like that I would think would go through an SI. Now, it wouldn't be confined to just that, right? It wouldn't be confined to sort of minor problems like that. There will be substantive changes in immigration law, changes in a whole series of matters that currently flow from the European Union, some of which could be quite significant. And so you've got the problem there is it generating a lot of secondary legislation, possibly some primary legislation, things that may not resolve the issue in the way that your chairman was raising earlier. He said, oh, well, you know, if you have a problem and you haven't got time to get it through, what happens? That's why it's a difficult problem.
And just on timetable, and of course I completely understand that you can't give any committee a running commentary on negotiations, on positions that the government would take, but could you at least say when do you expect the government to agree a clear set of objectives for Brexit negotiations, i.e. do you have a target of when you want all those objectives?
That's one of, I think, probably the primary reason that the Prime Minister has said we're not going to trigger Article 50 until sometime in the new year, effectively, I mean, after the end of this year. Because we're going through that process as it now stands. I can talk you through the process if you want to hear it, of assessing negotiating aims, negotiating tactics, the legalities, the very things we've just been talking about, legalities of Article 50, the endgame legalities, all those things really have to be fairly clear before you start. And so we'll arrive at that sometime in the new year, I think.
So you'll have all your objectives in place sometime in the new year, so right January, February?
I'm not going to give a guess on that with the best will in the world. I mean, I've said before, I would rather go a month late and get it right than go a month early and get it wrong. You know, that's and it's a slightly flipped phrase, but it actually characterises exactly how we think about it.
But early in the new year.
Well, I'm not
your target.
I'm not going to draw. The Prime Minister has made well, certainly one very public comment and one I think is implicit in what she said. One, it's not going to be this year. Two, she's going to be she knows the British people expect us to be expeditious about it.
Absolutely. And after reaching that negotiated position, when will the government set out those objectives, or will you just not set out those objectives at all?
Oh, well, I think we'll set out some objectives, certainly. The level of detail of the aim is another matter, but the overall aim will be set out fairly clearly.
And
apart from anything else, you've got Parliament quite rightly having an interest in it. As I said yesterday to the Lords Committee, we will meet that as far as we can without jeopardising the overall aim, which is to get the best possible deal. So without jeopardising the negotiating strategy. But also, we have to write, when we write to the Council, to Mr Tusk, under Article 50, we write a letter, and I would assume that letter would include a statement of what we're trying to achieve.
So that would be around early in the new year as well?
As I said, I'm not going to be drawn on the early or anything else. It's not going to be this year.
Last week you said your department would hold roundtables with key stakeholders in a series of sectors, which you also then mentioned yesterday to the Lords EU Committee. Can you explain in more detail how the process actually will work? Will you publish open calls for evidence or contributions from stakeholders, or will you and other departments select those whom you wish to hear from?
It's a bit of both. I mean, some of it's self-selecting because, frankly, anybody who is concerned about their own industry will be wanting to have round tables. So, for example, I think it was last week, the Shriti Vadera's group from the city had a round table which was chaired by the Chancellor. I've got one this week which is a retail one. But you've got that. You've also got a whole series of bilaterals. I just saw the NFU before I came over here. I've said in the House, I saw the TUC, the very first people I saw were the TUC, the Director General there, the Secretary General there, fishermen's organisations, you name it. So there's a whole series, right? So it's a mixture of us being systematic about where we think there's an issue and people who are concerned coming forward.
And therefore, that's how you're ensuring it's wide-ranging and representative. Right?
Yes.
There is a...
Yeah. And bear in mind, sorry, I've left out a whole section. Bear in mind as well, I'll put to one side for a second the devolved administrations, because they've got a separate set of almost parallel operations going on. But also every single department of state, virtually, is also being asked, and was tasked at the beginning of the summer, it's really the first thing I did, was tasked at the beginning of the summer of coming back with a whole series, with their primary concerns and their own, as it were, client group, I hate the phrase, but something like their own client group responses. So that's happening too. So I can't think of any other way of making this a more exhaustive and comprehensive process.
And every department has actually set aside resource for this?
Yes. Indeed, more of the resources in the departments than it is with us, really. I mean, my department, as I said yesterday, is subject to some priapic humour, is quite small, and but it's grown rapidly. It's about quadrupled in the last month, really. But it's still only about 200 people, if you don't include UCREP and so on. What we're doing, the strategy we're taking, is for having a small number of very high calibre civil servants from each of the main departments, not trying to replicate the entire policy wing of, let's say, of the Home Office. You know. That makes it work better, frankly. It's more effective, we're not duplicating, it doesn't create turf wars, and it's a better way of doing things. So that's how it works.
And how will it work when you start negotiating?
Well, you're leaving it a step. You're leaving it a step. I mean, the step between now and then, the start of negotiation, will involve a degree of assessment and quantification of the size of the problem. So let me give you an example. Somebody has said that non-tariff barriers, I mentioned to the chairman earlier, are bigger than tariff barriers, and they've cited various ways, how it affects just-in-time and so on. We'll do the quantification of that, so that before we get to the start of negotiation, we'll have an idea of what's big, what's small, what matters, what doesn't. Now, we won't necessarily publish all of that, because that's a gift to the other side.
But you'll have that in the new year?
But we'll know it.
Very good.
We'll know it by the new year, I'm sure.
John
Thank
Barrett.
you.
Secretary of State, welcome. These are could be complex negotiations, and one doesn't want to obviously compromise your position as we start the process. But many of us believe that if access to the single market cannot be gained on terms that are reasonable to both sides, then certainly for those goods that are subject to tariffs, we should not be afraid to fall back on WTO rules and tariffs. Is there any reason why we shouldn't be doing that? Does that hold any fear for you as we enter these negotiations?
I'm not going to commit to any particular strategy at this point for obvious reasons. But, well, firstly, let me offer a philosophical approach to negotiation. I think it's a very bad idea to go into negotiation fearing any of the outcomes, because that weakens you in one respect or another. And it's one of the areas which we will assess. I was just speaking to Mr. Zahawi about the calculations that will go on, and we will assess not just what the costs, if you like, of a given stratagem is, but also what the policies that go with it are. So people might say, oh, it's going to cost this or cost that or cost that. They haven't necessarily taken on board what we might do to mitigate the costs. So I see nothing to fear in any outcome.
Good. On the subject of immigration, many, certainly within the EU Commission, are wanting, or certainly the early suggestions are, linking immigration or free movement with trade negotiations. I mean, many of those who voted out, one of the key reasons was that we had an immigration system that was actually discriminatory. It discriminated against the rest of the world outside the EU, and what was wanted was fairness, whatever the criteria that is going to guide the policy going forward. It's got to be fair, so there's no discrimination. I mean, is that the sense of the position within government as you see it from where you're sitting?
My job is to get the powers back, to respect the judgment of the British people in the referendum, which I tend to think of as a triptych of control of laws, control of borders, control of money, to respect that as much as we can in the negotiation, as we will. But when we get it back, it's for the Home Office to make the decision on how they're going to use that power. So whilst I have some sympathy with your description of it, it's not actually going to be me that makes the decision. It'll be a cabinet decision on how we actually decide on the final policy.
Final question. The subtlety of that position, of course, is that if you adhere to the principle of fairness, whatever the criteria is used, whether it's the Australian point system or some other criteria, but essentially adhere to the principle that there will be no discrimination, you effectively divorce immigration and free movement from the trade negotiations, because you can offer nothing special to the EU as such.
Sorry, you need to explain that again to me. I didn't quite
Very
follow that last
briefly,
part.
the subtlety of the principle of fairness is not only is it that it's right, and that's your starting point,
Sure.
in that you will not discriminate against one region of the world against another, but that in pursuing the principle of fairness, you actually divorce, in effect, immigration stroke free movement of labour from the trade negotiations.
I did actually understand it the first time.
I'm just giving you time. I'm giving you time to think about the answer.
I thought you were trying to draw me into a negotiating gambit via the policy. So yes, and for obvious reasons, I'm not going to be drawn. So.
Can you not say anything though? I mean, can I just press you on this? I mean, you say it's a key plank of the campaign. Well, immigration is important.
And the Prime Minister has made it very plain that the current system cannot be allowed to stand. She said, we're not going to have free movement. As it now is, and she's talked about control of the borders. So I don't think there's any doubt about the priority we put on this, and I don't think our European partners would have any doubt themselves about the priority we put on it, and that some of them have commented publicly in disagreement with that. For example, the Irish Taoiseach, I think, commented Bratislava possibly, or certainly over the weekend, disagreeing with us. But it's plain, we put a high priority on it.
Okay, thank you.
Mike Gates.
Thank you. You mentioned that you'd had a meeting with the TUC, which is, of course, very welcome, and unusual for the government in recent years to have such early meetings of ministers with the TUC. You've previously said...
I do have form in this area.
Yes, and that's very welcome. And perhaps you'll then be able to answer on the next question, which is, you previously said that workers shouldn't lose their rights as a result of Brexit. Is that your personal view, or is that the position of the government?
It's my personal view, but I have no reason to believe that I've not been disagreed with.
So there's been no discussion within government yet about whether, as a consequence of us leaving the EU, there will be an erosion of workers' rights?
No, not on that explicit issue, but I have not, and what I've said to other members of the committee is, we're not going to get drawn into the policy elements of this. It has, in detail, but it has, because it has implications that would, well, let me put it that way. If you lay out red lines, what your negotiating opponent does is head straight for that red line and use it as a lever against you. All right. So I do not propose to elaborate on the comment, but the comment stands.
But it remains your personal position and not the position of the government. Okay. Now, yesterday you told the Lords EU Select Committee that you're going to ask businesses to give you quantitative assessment of the impact of various scenarios on their sectors. How are you going to assess that data, the validity of that data?
You've elided two things. I think I was talking to Lord Green, and what I said is we will carry out quantitative assessments. And yes, of course, some of the information will come from there. But the same way you test any data given to you, you look at how it's calculated, you ask for the underpinning.
You will carry out, or the businesses will carry out?
We will carry out some of our own. Yes, that's right. So, and the example I cited, the one I cited earlier, was people comparing the effect of tariffs and the effect of non-tariff barriers. How do you assess that? How big are the problems? Where are they?
You also said that your department doesn't yet have the capacity to assess that data. When do you expect to have that capacity?
Well, the trite answer is before we need it, but the sequence of events is a little like this. We're at the moment doing the round tables and the bilateral discussions. We will then be asking for data and submissions from them, which is already coming in some cases. We will then be doing the assessment. So that's a little way away. The department's doubled in 1 month. I suspect it'll double again in size, and that's about the point we'll be looking for that data, that information.
Will that be before or after Article 50 is triggered?
Before.
So we won't be able to trigger Article 50 until you've actually got your department at capacity to carry out functions that you will need to do.
To carry out those functions, that's right. That's self-evident, I would have thought.
And will you be drawing on the balance of competencies process and all the documentation that was produced by ministers before the referendum, the whole process that was gone through when William Hague was Foreign Secretary and David Lidington was the European...
Most of this is a new process. I mean, it's a very... I mean, I think the committee should understand it's a very big process. I mean, there's a lot of work going on. Pretty much every department of state's involved in it, and they will, of course, be doing a fair amount of contributory analysis themselves, and then we'll be challenging it, really.
And final question now. Given the clear reluctance that you have to state what your negotiating position is going to be and not give detailed answers to us today or yesterday, how long do you think you could sustain this position? Isn't the reality that it will become politically impossible domestically, not just internationally, and therefore it might be better that the Prime Minister and her new team actually got a mandate for the British people before they trigger Article 50?
Well, they
In
have
other
a
words,
mandate.
and no, an early general election before the triggering of Article 50.
Well, I'm
Give it to Jeremy Corbyn.
I'm tempted to say that's above my pay grade, but it does rather put the entire rest of your questioning in context.
No,
Yes, it
that,
does.
no,
Yes, it
no,
does.
no,
Yes, it
no,
does.
I'm sorry, no.
Yes, it does. I'm
My
answering the
questions-
question.
My questions are different questions, and they are the kinds of questions that people in this country want answers to, and your job is to answer them.
What the people... No, my job in the first instance is to make decisions on behalf of the people. We've got a mandate like no other.
We live in a parliamentary democracy.
We have got a mandate like no other, and it's our job to deliver on that mandate. And it's our job to do it as best we can, which means carrying out a negotiation in an intelligent way, which means making the decisions on the basis of the data which you collect, which you analyse, and then you make the decision on that basis, not the other way round. It may be your approach to say, oh, because we're asking the question, you've got to tell us the answer before you've worked it out. It seems to me an utterly daft idea.
So you haven't worked out any answers to any of these questions yet?
We've worked out some answers, but not the ones you've asked, not the ones to the questions you've asked. And frankly, we've got a major exercise underway. We're going to be looking at every single sector of British industry. Every single Department of State has got a workload underway on this. They will come to intelligent conclusions, and that will drive the outcome, the empirical outcome to this process, not politically driven answers that allow you to say, should you have a general election?
I think Mr. Gates's questions have established the conclusion of the committee that about the level of negligence about not having this in place before the referendum in terms of contingency planning.
Thank you, Chairman.
But that, of course, is absolutely
I'd say not above my pay
that is
grade, that's
absolutely
before
not,
my pay grade.
It's
Not
absolutely
me, Gov.
not your responsibility, Secretary of State.
Yeah.
Daniel Kaczynski.
Thank you. Good to see you back in government, Mr. Davis.
Thank you, Mr. Kuczynski.
With regards to, we're obviously very clear that there's accentuation of the fact that there was a lack of preparatory work on the possibility of post-Brexit by the previous administration. And Mr. Tusk and others have obviously clearly indicated that the ball is in our court for triggering this. But could I ask you, bearing in mind that we have up to 2 years for this renegotiation process, what are the delays in invoking Article 50?
Well, the primary delay is doing the analysis necessary. I mean, let me, I don't want to get sucked too far into what happened before I arrived, but let me say this. It would have been quite difficult for any government to do the level of analysis that we are undertaking now. I mean, it is enormous. And as I say, every Department of State is involved in it pretty much. So that's the first thing, and it's time consuming. It simply is time consuming. First, to collect the data, to establish the nature of the problems. Let me give you another example. The City of London, there's been a lot of concern about things like passports and so on, and some companies have raised issues about this. Now, some companies care about it, some don't. We need to understand why some care about it and some don't, what the differences are. We need to understand whether there needs to be a policy answer to it or whether they can mitigate the problems themselves, either by brass plate offices around the place and so on. There are a whole series of issues, and that's just one sector. And the city remembers an ecosystem. It's not an industry which fits together like a complex Jenga tower. So there are a whole series of these studies underway right now, and some still to be started, which will take time to complete. And it seems to me the only way to carry out such a negotiation responsibly is to do the analysis first, draw up your priorities off the basis, your negotiating priorities, clear what the national priorities are, on the basis of that analysis, and then design your negotiating strategy around that. That's why it takes time. And I make no bones about it. I think the British people want us to do this properly. They don't necessarily want to do it incredibly fast.
I understand that obviously there's a huge amount of work to be done, analytical work, and we want to be ready for those renegotiations with all the facts at our disposal. It's not an issue, though, however, of a lack of resources for your department, is it? Do you have sufficient...
No. There's a time constraint in the sense that the department's come from scratch. It didn't exist 2 months ago, or just over 2 months ago. Most people around this table, they may not want to admit it, know what Whitehall is like in August. It's, the recruitment process is not as straightforward as you might think. So it's taken time. But there's no way around that. It's not a shortage of money, it's not a shortage of resource. It's just a question of establishing the organisation in place. As I said to the Lords Committee yesterday, at the moment it's mostly civil servants, in fact it's all civil servants with a few secondees. And they're all quite young, smart people, but they may not have experience in the city or in industry or in various other areas. And the next phase really will be to bring in some grey hair to provide that experience. So it's not resource in the normal sense of the word of money. There's not a problem there.
The Europeans have been, our European partners have been, I think, very understanding and certainly in public about our delay thus far. Obviously, they are keen for us to invoke it as quickly as possible. Do you envisage a time when they will start to say publicly that they are concerned about the delays?
Some have. I mean, I think.
Have you had any discussions with them about that?
I think I'm right. Well, the Prime Minister's been seeing a number of them, and it may well have come up in those discussions. But I don't think it's material. The French government have been saying they want it to be precipitated soon. I think one or two members of the Commission have said that Mr. Juncker has said he wants it precipitated soon. But they are the other side of this negotiation. We're not necessarily going to do everything they say when they want us to when they want us to do it. The counter to this is that they need some time too. I mean, for example, to give you the parallel to this, Michel Barnier, my opposite number within the Commission, if you like, is just at the moment about to establish his own department of 25 people, not 200 or 400 people, but 25 people in the first instance, so that he can do his analysis. And they will need to work out for themselves what the consequences of our negotiating requests or asks are. And they're starting that process too. So I don't think it's wasted time.
Okay, thank you.
I can recognise some of the young talent that is supporting you in this role, because I'm familiar with it from my time as
yes, thank you for the training
as a minister. However, I'm slightly concerned about your comment about grey hair, and as much as has it actually proved rather more difficult to find experienced civil servants to come and join your department?
It's not. You say experienced civil servants. I mean, the question
and others of.
Well, the question is. Well, you mean outsiders?
Well, yes.
Well, no. For example, this morning we had an offer. I probably shouldn't name the company. We had an offer of 3 senior partners from a very major law firm in this area. So, and we've had other offers as well. So no, there's not a shortage of interest in getting involved in this. Indeed, for many of the companies in the city, many of the companies in business in Britain, there are strong interests, shall we say, in providing us with good caliber people when they can. Some of the interest groups, not companies, are doing their own analyses as well, which we will incorporate and draw on too. I mean, that was one I was talking to this morning. So I wouldn't worry. I mean, I'll tell the committee if I run into a constraint on this. I'm very happy to do so. But I'm not at the moment concerned about that. There's a natural limitation on how long it takes to set up an organisation. I'm setting up a battalion from scratch, basically. Put it in words that you would be familiar with. I'm the recruiting sergeant, the adjutant. Well, actually, it might be a battalion. We'll see when we get there. It will be as big as it needs to be.
Okay, Andrew Rosner.
Thank you, Mr. Chairman. Good afternoon, Secretary of State. The people voted to leave the European Union. They expect us to leave the European Union. And we understand that it takes time to get these things right before we can actually do it. But in the meantime, can you reassure the public? Can you take actions, even small symbolic actions, to indicate that the government is absolutely serious, deadly serious about doing this? Because there are jitters and there are people worried that this isn't actually going to happen in the way that they thought.
The Cabinet decided at the beginning of the summer, and the Chancellor carried out, I think on August the 14th, a statement that we would underpin spending, structural funds, CAP funds and so on. So if you wanted a signal that we wanted to reduce the jitters and say we're definitely doing this, that was one level not very cheap decision. So that's one step down that route. The second thing is I say time and again, this is a decision that's been taken by the people. This government's job is to deliver it. Other arguments notwithstanding, and those arguments have been made over and over again. There was a debate in the I think in Westminster Hall last Monday on whether there should be a second referendum, and we've rebutted that clearly. The Prime Minister has said time and time again, no second referendum, no reversals, no avoidance, we're leaving the European Union.
As a transition between now and when we leave the European Union, is there a possibility that we could look at EFTA as a way of continuing trading on the existing arrangements and being outside the EU, but so having the existing trading relations which we all want to see, and leaving the European Union much earlier by actually having that kind of transition?
Well, no, I don't think so. I mean, I don't want to get into, and I won't get into, what arrangement we end up when we leave. There are people who argue that as an outcome. There are others who argue instant departure, so we're not going to get into that. But no, I think this is the case. The strategy of the government is to depart the Union at the end of the Article 50 process. Up until then, the government will obey absolutely the European Union law, and we will be a good European Union citizen. That's the approach we're taking. We think that's the best approach in terms of our responsibilities. But we also think it's the best negotiating approach, and it is an indicator that at the end we're going to be a good global citizen. We're not going to walk away from our responsibilities. We are going to take a strong stance on European matters of defence and security and a whole series of other things, and this is a bit of an indicator of that.
But where there are things we can do that would be legally okay to do, that sort of show that we are symbolically going in a different direction. For instance, one example is new passports that are going to be issued from now on would go back to the traditional blue British passport rather than the pink things that we've been having since we joined the EU. Could we do symbolic gestures such as that to show the British people that we are absolutely serious about leaving the EU?
Attractive as the idea is, we're not in the business. Well, at least I'm not in the business of symbolism. I'm in the business of delivery on this, and that's the point. That's the point that I think the British people will take.
And on that very point of delivering, in your deliberations, your negotiations, discussions about Britain's future, the United Kingdom's future with the EU, what assurance can you give that you are taking into account the interests of Gibraltar and the British overseas territories and crown dependencies, but particularly Gibraltar, that have a huge amount of concerns about their position following Brexit?
Well, we are, and indeed I'm seeing the Chief Minister of Gibraltar almost immediately after this meeting.
Thank you very much.
Mark Hendry.
Secretary of State, you seem very reluctant to get into specifics because obviously, as you say, you wouldn't want to expose your negotiating hand. But as you'll recall, straight after the referendum, there was huge uncertainty in the markets. The pound slumped, share prices dived, and whilst there's been a bit of a recovery with the pound, because basically people understand that there's not going to be a rush to invoke Article 50, clearly you've got a run-up to Article 50, which gives you some breathing space and gives the markets and many of our major investors time to speculate which approach you will take, because whilst you clearly don't want to be transparent about this, what markets want and what businesses want, what investors want is certainty and to some degree transparency that the outcome is going to be something that they can live with.
Well,
now you've made it quite plain that you're not sure that an EEA model or an EFTA model is for Britain. Do you envisage some sort of bespoke arrangement that you're going to keep secret until the last minute, and that at the end of 2 years is going to be brought out like a rabbit out of a hat that the international community, in particular the business community, are going to be satisfied with that. And in the meantime, what damage do you think that's going to do to our international standing in the markets and the strength of the pound and what's happening with investment in this country?
Let me take that apart from the beginning. Firstly, the description of the financial markets was just simply not true. The FTSE 100 and all the various indicators are good. The standing of the pound is not in a poor place. Indeed, a previous governor of the Bank of England said that's where it ought to be. So I'm not in the business of speculating that. But the description you've given is a little like descriptions that were being given during August, when everybody was trying to find things to blame on Brexit. And then, of course, all those things that they blamed on Brexit dissolved. They weren't there. So I'm afraid I don't. Well, let me finish. You asked the question, I'm going to answer it. So first off, your description of the economy is simply not the case. Secondly, of course, I have the advantage of having worked in big business. And the first thing to say to you is that big business decisions are not taken on the writing of one commentator in the FT. They're taken over quite considerable periods of time. They're not taken on the back of the movement of the FTSE on one day or another. They're taken over long-term assessments. And so you'll have seen that the foreign direct investment into this country last year, after the election of a government that had undertaken to have that referendum, was as high as it's ever been. You'll have seen people like SoftBank putting money in the country in a big way. You'll have seen GlaxoSmithKline and Siemens, who previously were very concerned about this, or said they were, saying that they were going to continue to invest. In the GlaxoSmithKline's case, I think, well, certainly hundreds of millions, I can't remember the exact number. So I don't, frankly, accept the premise. But let's then take the next step as well, which is what business views as uncertainty. A businessman wants to see a decision taken on the basis of the facts. He wants to see a government representing the national interest in the national interest. And that's what this government is doing. I think if I were still in business and I were worrying about whether I invest in Britain or not, I would be panicked, not by a government that takes its time and does it properly, but by a government who rushes to do something in a tremendous hurry without thinking it through. So I'm afraid the entire premise of your question is flawed.
Well, you say that, Secretary of State. I know you've had discussions with the Japanese ambassador, but let me give you a short passage from the report that you were presented with. What Japanese businesses in Europe most wish to avoid is a situation in which they are unable to discern clearly the way Brexit negotiations are going, only grasping the whole picture at the last minute. It is imperative for the UK and EU to regain the confidence of the world and ensure their unwavering competitiveness by increasing the predictability of the Brexit process. Now, that's not just true with Japanese companies. It's true with companies around the world who are wondering whether or not to pull out of Britain because we won't have access to the single market.
And you're basing that last statement on what evidence?
Because we won't have access to the single market.
You're basing that last statement on what evidence?
Well, you've said yourself, I know you've been slapped down for saying it, that we may not be in the single market when this process is finished.
Did I say that?
Well, that's what I read in the newspaper.
You're basing that on what evidence? In newspaper articles and all that?
Well, you do have the memorandum.
Let me deal with this.
Let me finish what I'm saying. Now, you mentioned SoftBank buying Arm Holdings. That is not building factories and new facilities and thousands of jobs in Britain like Nissan or Hyundai. What that is a British company that's been taken over lock, stock and barrel by a Japanese company. Now that isn't it's investment in the giving us money for the company, but it's not jobs and hard manufacturing that we didn't have before. So let's not mix this thing about SoftBank and Arm as if it's the equivalent to the big car investments that have been made in this country.
You were the one who raised the FTSE numbers, actually.
No, I'll come back to the FTSE. Many of the companies listed on the FTSE are foreign owned, and that's why the FTSE has not been affected to the same degree.
250.
So where was the question at the end of that?
No, I answered some of your points.
Well, let me deal with the Japanese point first, if I may, Chairman. The simple way of dealing with it is to ask you to go back to the Today programme on the first day of the G20 when the Japanese ambassador went on and was very plain about how attractive Britain is and how attractive Britain will continue to be. Sorry.